appeal in the matter of British Broadcasting Corporation and BBC Pension Trust Ltd and another.
Mr. Green.
Hello, my lords. You have where we got to in relation to the power to terminate accrual under respectively Rule 22 of the 1949 rules and Rule 18 of the current rules. We got to that in yesterday's transcript right at the end, page 285, line 21 to page 287, line 19. And the submissions that I was then making were made in connection with both Rule 22 of the 1949 rules, which we'd observed had been referred to in this court as a winding up provision, and the submissions were likewise addressed to Rule 18.1 to Rule 18.3 of the current rules. And just to encapsulate the submission in a single long sentence, the submission was that whatever may, under those rules, whatever may or may not be envisaged against a backdrop of scheme cessation, does not necessarily tell you anything significant in relation to the meaning of interests in the third proviso to an amendment power, operating as it does in relation to an ongoing scheme, which is providing for ongoing benefit provision. And there is no basis for construing the amendment power through a prism of an assumed or assumed imminent winding up. That was the submission. Now, Rule 18 is the present-day successor to Rule 22 of the 1949 deed, and the introduction of Rule 18 of the current deed in place of Rule 22 cannot have changed the meaning of interests in the third proviso to the amendment power. The trustee is content, therefore, for the purposes of these proceedings, to leave this particular submission at this, that Rule 18 of the current rules is to be treated as equally relevant or irrelevant, as is Rule 22 of the 1949 deed, to the question of interpretation of the word interests before this court. And beyond this, the trustee does not propose to go, save, and I have to put down this marker, I'm afraid, save to observe lest the trustee's current silence is misinterpreted and invoked against it in the future, that as my learned friend Mr. Spink alluded to, there are, behind the present proceedings, substantial disagreements between the trustee and the BBC as to the meaning and use to which the BBC can put Rule 18. And the trustee's position, without wishing to go into it in too much detail, the trustee's position may be summarised as follows, and the summary has two limbs which pivot around the word but. And what comes after the word but is the important bit. It's the trustee's position that Rules 18.1, 18.2 and 18.3, as the successor to Rule 22, provide via the gateway of the BBC's cessation of making contractual contributions a potential means for an orderly transition into winding up. But that Rules 18.1, 18.2 and 18.3 are not there for the standalone purpose to enable the BBC, with the trustee's cooperation, through the trustees declining to exercise its Rule 18.2b discretion, to terminate accrual against a backdrop of an otherwise indefinitely ongoing scheme. So the trustee's position is that the rules are not there for the standalone purpose to enable the BBC with the trustees' cooperation to terminate accrual against a backdrop of an otherwise indefinitely ongoing scheme. The Rule 18 machinery may have the effect of terminating accrual along the road to an orderly transition into winding up. And in that orderly transition to winding up, and in that orderly transition, winding up may be postponed. But in the trustee's eyes, termination of accrual as such is not the object and purpose of the provisions. Now, the disagreements between the trustee and the BBC in relation to this were at one point going to be included for determination in the Part 8 claim in this case. And indeed, questions for inclusion in the Part 8 claim relating to those matters were drafted. But the BBC decided, and the trustee was glad of this, the BBC decided not to proceed with their inclusion. And the Part 8 claim has accordingly proceeded by reference to Rule 19 only. So the point to be made here, therefore, is that there are issues behind the way in which my learned friend is making submissions to you on Rule 18 before this court. And that's really why the trustee feels obliged to make the observations it has before you. There are issues as to how Rule 18 of the current rules should be seen, and issues as to whether the BBC's portrayal of Rule 18 as if it were a standalone power, subsisting alongside the amendment power, enabling the BBC to terminate accrual, is not without controversy, of which I have to say the BBC is aware. Now, it's not the purpose of these proceedings to get into that controversy. You have our submissions as to what may or may not be said as to the significance of the existence of Rule 18 alongside the amendment power. And it's a matter, obviously, for your lordships to judge that issue for yourselves. Which, unless I can help you further in relation to that, brings us to Bradbury.
Okay, just before we go on, there's one, it doesn't really make any difference to anything, but it comes out of, for example, the obvious fact that what was Rule 22 is now Rule 18.
Yes.
I think a question was asked right at the start about re-adoption and the amendment process. I just wondered if you could help us a little further with that, because not that it makes a difference, but just so we understand the position, because we've got relatively few extracts in the supplemental bundle. What we have, for example, from 2006 suggests that there was a complete re-adoption then, but I think there may also have been a complete re-adoption subsequently. Can you assist us with that?
I'm just leaning backwards. I'm not intending to be rude to your membership, because we do have an email. The answer to your question is that it's not clean. There's no clean answer. The evolution of the transition, if I can put it like that, between Rule 22 and as it appeared in the 1949 deed.
The question isn't actually necessarily specific to Rules 18 and 22. It's a more, if it's possible, to have a slightly more general understanding.
Okay. I think best of all is if we hand up to the court and to the other parties a narrative as to the transition. It was an evolution.
Right. If to assist my lord in particular, could that be sent electronically?
Yes.
Please.
We'll put it.
I don't think we need to take up time now, but I hope it's completely uncontroversial.
We'll ensure it is, and we'll put it into an appropriate form.
Thank you.
Okay, thank you, sir.
Lady, if I could just, on that point, remind you of something I said to you when Mr. Tennant was on his feet. I took you to the list of deeds at the top of the working copy.
Yes.
And that refers to the 2016 deed.
Yes.
Which certainly is a complete re-adoption.
Yes, but I think there was one earlier as well.
And
at least in
certainly,
2006.
it happened. Answering your specific question, outside the context of Rule 22 and its evolution, it was a regular process of complete re-adoption.
Right.
Albeit with changed structure, format, etc. But in terms of here's a new deed and rules, that happened on a reasonably regular basis throughout history, and you could be given a list of all the times that it happened if that would be helpful.
And we will. And we have got a list, I've just seen it, with colour coding, which deeds are restatements, which deeds are amendments.
Right.
You'll have them. And
If you have it, that would be very helpful. Thank you.
And you'll also have, you'll be able to travel through the evolution of Rule 22 as well, with a bit of luck. Which brings us to Bradbury. Now, your lordships, my lady, will have read it, and as my Lord Justice Lewison observed in the passage recorded in the transcript at page 140 of day 1, you've not merely read it, you've reread it a number of times, as was not unnatural given what was the largeness of the BBC's claim in relation to it, namely that its ratio is binding on this court in this appeal. Now, we don't propose to labour it. My Lord Justice Lewison made his view very clear, and we obviously completely agree. Bradbury simply did not decide the present point. But if it would be of assistance in relation to that narrow question, we would now propose to assist you shortly to explain in a number of brief propositions why it is right to put Bradbury to one side for the purposes of this appeal. And for that purpose, we would ask you to have Bradbury just open alongside you, if you please. As you'll know, it's Authorities Bundle 2, tab 23, and the pages to have open are pages 684 to 686. That's paragraphs 34 to 42, which are the paragraphs in point. And I know you've read them many times, and I'm certainly not going to take you through them, and certainly not line by line. Now, as you very well know, the question that this court has before it is the interpretation to be placed on the word interests in the third proviso to the amendment power. And as we noted yesterday, it's a question having as its focus the specific questions on the claim form. Now, that simply was not the question before the Court of Appeal in Bradbury. And the idea that the ratio of Bradbury might actually bind this court starts off distinctly unpromisingly as a result, before emerging upon analysis as simply wrong. The question before the Court of Appeal in Bradbury, so far as it is said to bear on the issue before you, was what the Court of Appeal described as issue 1. And as you know, that's set out at 684 letter D, issue 1. And the question was what was done permitted under the 2000 amended version of the basic salary definition, or was what was done a breach of that rule? And it's important for an understanding of the narrowness of what was in issue that what had been done by the BBC, and so was in issue in Bradbury, was to declare that part only of a pay increase which the BBC had conferred was pensionable. That was the issue. It was a very narrow issue. Was it permissible within the definition of basic salary that had been introduced in 2000 for the BBC to have declared that only part of a pay increase was pensionable? Now, even with the fairest and most indulgent of wins, what the Court of Appeal said in Bradbury in relation to that question does not, cannot, as a matter of ratio, bear on the question before this court at all. In Bradbury, the Court of Appeal, in answering the specific question before it, confirmed that, in accordance with the literal wording of the 2000 edition of the definition, it was indeed open to the BBC to declare that part only of a pay increase was pensionable. That was the issue, and that is what the Court of Appeal decided in relation to it, for the reasons set out in paragraphs 34 to 38 of the judgment of Lady Justice Gloucester. And that decision and those reasons, that decision in relation to issue 1 and those reasons, 34 to 38, did not require any decision as to the meaning of the word interests in the third proviso to the amendment power, and the Court of Appeal did not actually or by implication decide issue 1 by reference to the meaning of that word in its analysis between paragraphs 34 to 38. That is the general point. But there is a specific point having regard to the particular aspect of Bradbury which is emphasised by the BBC in putting its case in this appeal. How the scheme actuary could have justified the provision of a no substantial prejudice certificate in relation to the introduction in 2000 of the amended definition. And in relation to that, that cannot be said to be part of the ratio of the case either. Because as my Lord Justice Lewison pointed out, and as is apparent from the final 3 sentences of paragraph 40, so the argument was deployed by Mr. Bradbury at 39, but as is apparent from the final 3 sentences of paragraph 40 over the page at C, how the scheme actuary could have justified the provision of a no substantial prejudice certificate was not actually an issue relevantly arising for decision in this case. There was no challenge to the validity of the introduction of the provision. There was no suggestion that it had been invalidly introduced. All there was a suggestion that it was an aid to the construction of the words that were introduced, that the scheme actuary had given the certificate that he had. And accordingly, the discussion of this point at 39 to 40 and at 42 was not part of the ratio of the case at all. And what Lady Justice Gloucester said in answer to the point in 40 and 42 is simply an application of what she had already said in 34 to 38, including 37, the ratchet effect point. The point being, in a nutshell, that because pensionable pay increases were already in the gift of the BBC pre-2000, subject to the contractual constraint that once the level of basic pay was identified as pensionable under a subsisting contract, it could not be subtracted from, the certificate of no substantial prejudice given by the actuary in 2000 would indeed have been justifiably provided. Lady Justice Gloucester's observation in this respect was not founded on making any finding in relation to the meaning of interests either. It was no more than what it purported to be, an indication of why Mr. Bradbury's attempt to enlist the actuarial certificate point as an aid to construction, penultimate sentence of paragraph 40, went nowhere. But apart from the point getting Mr. Bradbury nowhere as a matter of substance, it was plainly a non-starter of a point in any event. The meaning of the words of the 2000 amendment could not depend on whether the actuary had correctly certified the same as not involving substantial prejudice. That was to put the cart before the horse. The meaning of the words must come first, first. It's obvious. Whether they involve substantial prejudice is a consequential issue which only arises for determination in light of that. All of which is to say that Bradbury really has nothing to do with, nor does it have anything significant to contribute in relation to the issue in the present case. And the BBC's submission that what was decided in Bradbury precludes this court, which has heard and is fully engaged with all the arguments as to the meaning of the word interests, as developed at length before it, precludes this court from deciding this case as it would wish, is simply wide of the mark. Unless we can assist your lordships further, those are the trustees' submissions.
Can I just make 2 points?
Yes.
First is on Bradbury. We don't know what it was that the actuary was considering. I mean, it may be that there are a package of changes introduced, including this new definition, some of which may have affected detrimentally active members' interests, others might not have done. And we don't know whether the actuary considered the package as a whole or considered amendments individually. The second is a question I'd like to ask, if I may, which I should have asked earlier. It arises out of the judge's answers to the questions raised in the order. And it's not specifically for you, Mr. Green, but I thought I'd better raise it now before everybody has their chance to say anything more.
Thank you.
It's question 1D, and the judge's answer on page 86 of the core bundle. And the question is whether interests include the ability of members to accrue any future service benefits under the scheme. And the judge says, yes, on the basis that this question is directed to the possibility of the scheme being closed to future accruals of benefits. I wasn't quite sure where that qualification came from. He does make that qualification in his judgment, but where in the arguments is it made clear that that is the circumstance to which question 1D is directed?
Sorry, Mr. Tennant was about to assist me, but perhaps he might directly assist. Is that all right?
With your permission, my lord. My own reading of that is the judge was simply expressing that qualification to draw a distinction between the previous declaration he'd made, which also related to the ability to accrue future salary benefits on the same basis as currently, and then D said would have overlapped with that, so he was attempting to make clear that was a question relating to the total cessation of such benefits, not a modification of the basis of accrual. That's only.
And is that what the question was meant to capture? I see the judge's distinction that C is looking at accrual on the same terms as previously, and D is looking at the ability to accrue any future benefits, but it does go on to say under the scheme. So I'm not entirely clear what that question is intended to capture. But if everybody accepts that the judge's qualification does reflect an intended difference between questions C and D, then I understand.
For our part, we do accept that. I'm not getting an altogether enthusiastic response from but that was certainly my understanding of it.
I think it's all of our understanding.
Yeah, it's yours too.
Yeah.
Okay.
Sorry, it's also my understanding, and yes, okay. I think that's all I need to say.
Well, and whilst that was happening, I was getting a little bit of instruction in relation to your lordship's first question. It is observed, without any intention of disrespect, but of course the Court of Appeal was referring to a 2006 deed, when in fact the amendment had been made in the 2000 deed. And so, but putting that, not intended to be disrespectful, point to one side, In fact, the 2000 deed was a comprehensive restatement. It was one of those deeds of variation with all the clauses in it. And so the no substantial prejudice certificate was being given compendiously. And as your lordship says, who knows what was going through the mind of the actuary in relation to the compendious document, with perhaps swings and roundabout provisions in relation to it. Certainly, the matter was dealt with before the Court of Appeal on the basis of the individual amendment, and then would no doubt there might be discussion as to whether each individual amendment falls to be judged by reference to a substantial prejudice test, or whether looking at the whole picture is the more appropriate course. We just don't know. The truth is, as is, if I may say so, implicit in your question, this really is such a sidebar in relation to what was being decided in Bradbury. It was a speculative argument dealt with almost speculatively on its own terms. It doesn't really go to what was being decided on the case.
Thank you.
Thank you.
If I may take 5 minutes to clarify the representative beneficiary's position in relation to the submissions that you heard yesterday evening from Mr. Green about his footnote 13. This is the interest benefits equivalence point, which I think it is appropriate for me to do in reply, having myself raised that point in my opening, where at the time in my opening I made the general point that the judge was correct in his analysis on the meaning of the word interests, and that the significance of the point in the context in which he gave his reasons and undertook that analysis, and that the significance of the point being flagged in trustee footnote 13 needed to be viewed in that light. Where does it take us in view of a proper contextual analysis of the judge's judgment? Why, to remind this court, do we say that the judge's analysis was correct? In briefest summary, the central thrust of what the judge meant by interests, and indeed, and perhaps in particular, the word position that he used in paragraph 42 is, we said yesterday, and I repeat today, clear from the context. I explained that context yesterday, and my Lord Justice Lewison asked questions about and made observations about it as well. The way I dealt with it was to make the point, I think more than once, that the judge was being asked to consider two particular questions about whether two specific aspects of the benefit structure, I underline that word now in view of the way this point is developed, within whether two particular aspects of the benefit structure fell within the interests of active members. My learned friend Mr. Green at day 2, page 281, line 8 forward, also made the same point, this time by reference to a careful analysis of the questions on the claim form and the order the judge made and the brief reasons he gave in his judgment for some of those responses. That exercise that Mr. Green took the court to, in the way that he took the court to it, is, we say, a helpful way to illustrate the point I was trying to make in my own submissions, and it's an important point because it explains why neither the judge's nor the representative beneficiary's case on the meaning of the word interests in this particular context is impossibly wide. I use the words impossibly wide, taking them from Mr. Green's own characterisation of Mr. Tennett's submissions about our case, which certainly, in my view, do convey the thrust of Mr. Tennett's case against us. In summary, when talking about the position of the active member, a change to which, through a proposed amendment, would conflict with their interests, the judge only was being asked to focus on their position as regards two specific aspects of their benefits, future accrual and the salary link. And the judgment should be read accordingly. And we say on that basis is unimpeachable on the ground of attack from Mr. Tennant that I've just referred to. In other words, the analysis in paragraph 42 is focused on the position that I've just described, and on that basis shouldn't be read as laying down any broader principle about what the word interests may mean when considering other matters. The judge wasn't being asked to answer the question whether interests covers the position of active members in relation to the administrative structure of the scheme. And this court is not being asked to do so either. My learned friend has put before the court, as part of what I called yesterday a sort of floodgates argument, some suggestions as to why it can't be right that interests could extend to the active member's position in relation to administrative provisions in the scheme. And I made some responses to that yesterday, but the truth of the matter is that that's not on the claim form. The judge didn't need to consider it and didn't do so, and his reasoning and ruling in paragraph 42 and the associated paragraphs needs to be read in that light and understood in that in that light. One might envisage arguments one way or the other on another day about the question I've just alluded to relating to administrative provisions within the scheme. But we don't need to be troubled with those now, and nor, most importantly, should they be used as a point of attack on this aspect of the judge's judgment. The question is whether the judge was right to hold that there was no basis for implying a temporal limitation on the word interests in the particular context in which that question arose when focusing on the position of active members in relation to the two particular benefit aspects of the benefit structure. And on that, for the reasons that we've already submitted, he was correct. Allied to the point that was made by my learned friend, Mr. Green, last night about benefits and interests, he referred to again to the dictum of Mr. Justice Millett in Courage, and invited you to consider what the learned judge's thought processes may have been, and asked you to apply the metaphorical pencil to put some square brackets around certain words. We acknowledge that the point that Mr. Green has raised is, to use his own words, very interesting, with which we agree. Our position is that we've said all we consider needs to be said by the representative beneficiary, in this case, positively, as part of its case, about the possibility of there being some equivalence between interests and benefits. That's all that I've just said above. We appreciate that Mr. Green is addressing a slightly different point here, albeit flagging it as an interesting question. Namely, whether, if Mr. Justice Millett's dictum can be read as indicating that he considered benefits to be without temporal limitation unless accompanied by express words such as secured by past contributions, whether the same could be said for interests. However, we've also said all that we consider needs to be said in the context of this case on why interest contains no temporal limitation. and leave it in terms of the courage dictum simply in this way: if the court considers it to be a helpful additional way to consider that question, namely whether interest contains no temporal limitation, we will leave it to the court without further elucidation from us. I hope that's clear.
Yes.
Thank you. And I have no further points by way of reply.
Thank you. So, Mr. Tennant.
Just have a moment. My lords, my lady, could I start by addressing the future service issue? And in deference to my Lord Justice Lewison's observations, I'm going to deal in this reply by focusing first solely on the current deed, address all the points made by my learned friends in the context of that deed, and then I'll explain why we take issue with the learned friends' analysis of the 1949 deed and why you say you get exactly the same outcome from that deed as well. The first point I'd like to address is that the BBC is engaging in some sort of linguistic odyssey and is trying to give some convoluted or unnatural meaning to the word interest, which has changed over time. The first point to note is that the meaning given by the BBC to interest has not changed over time. Merely because we have used linguistically equivalent ways of communicating the same meaning does not entail the proposition that our case has changed over time. The essence of the BBC's case at all times has been that interest is a reference to the past service rights of the members under this scheme, and we have been consistent in that. Nor, in my submission, is that a convoluted or unnatural meaning of the word interest in the context in which it appears. And I'd like to illustrate that by basically doing what Lord Justice Lewison invited me to do, which is to put ourselves in the position of opening up Rule 19 for the first time in its current form, and to explain how we derive our position. Now, that's at Supplemental Bundle 10 of page 217. And I could immediately see, reading this fresh, that there is a restriction as regards the active members whose interests are certified by the actuary to be affected. And so obviously I ask myself, what does interest mean? And I go to the dictionary definition, perfectly natural, and I find there's a very wide range of potential meanings. But the first of those meanings it could bear is that it could refer to legal interest in or under a fund, and that would, in the context of an occupational pension scheme, connote legal rights to benefits under the fund. And I would note to myself that protecting rights to benefits would be completely consistent with the idea of a pension scheme as deferred remuneration for the service provided by the members of that scheme. The rights to benefits under a scheme are the earnings of the member, just as the wages are, and they are paid in respect of past service. So that's how I might come to the conclusion. I'm not saying that that's an inevitable conclusion. I'm just saying that's a possible conclusion as to the meaning of interests. Simply applying a dictionary definition. It's not a linguistic argument. And I'm certainly not saying that's the end of the inquiry. The dictionary tells me that interest could mean other matters. It could be as wide as relevant, all matters of relevant concern. It could simply refer to the ability of members under the scheme to accrue benefits in future. I accept that is also a possible interpretation of the word interest. And indeed, that was a possible meaning addressed by my learned friend, Mr. Green, yesterday. So keeping an open mind and to decide between these competing constructions, we ask ourselves, I ask myself, how does it fit with the way each of them fit with the way the word is used elsewhere in the deed. And I look first at proviso 2, and I see part of the same power of amendment, and I see the draftsman chooses the word interest to describe the rights already earned by past service, because that's in the context of a winding up. Proviso 4, which is the very next provision. The draftsman chooses the rights to describe rights earned by past service, in this case of pensioners and deferreds, as their interests in the scheme. Further, if I leaf through the scheme, I get to 10.6, which is at page 188. Now, in this provision, the draftsman specifically defines as an interest an entitlement to benefits or prospective entitlement. And further, if there's any doubt as to the meaning of what an entitlement or prospective entitlement to benefit means in terms of whether it's past or future benefits, any doubt in my mind about that is resolved by looking at the winding up power in 18.3, which is at page 217. And so I do page 8, it's 250. And that refers, in terms of the what's to be protected on a winding up for active members, in the third order of priority, to pensions and other benefits to which active and deferred pensioners are prospectively entitled. And that is connoting past service rights which have to be secured on winding up. And for good measure, I could point out that interest is used in the same sense in 10.7. If you look at 10.7, these are all points made in our skeleton. 10.7, at the end of sub rule 1, you have a reference back to interest under 10.6. And perhaps less relevantly, but also to be noted, if you look at 10.5 on page 187, which refers to discretionary trusts, and if you go to A, Roman 2 under sub-rule 1, the discretion allows you to pay sums to the person entitled under a deceased will to any interest in the estate. Now, it's obviously a different context, but again, interest is being used in the same way as being an interest in a scheme. So, my learned friend, how does my learned friend explain these examples? So I ask myself, how can these examples be explained? And the response given by my learned friend in relation to the second and the fourth provisos is that the context requires you to read interest out. So it can't include the ability to accrue benefits in those contexts. Well, that may or may not explain those two provisos. You have my submissions on that. Why would the draftsman choose the same word? But it doesn't help my learned friend in relation to Rule 10.7. In Rule 10.7, you are not compelled by context to read interest out. The draftsman has specifically chosen to describe the interests of beneficiaries, which includes interests of members, as being limited to entitlements, whether in payment or prospective. He is showing there that's what he means by the word interest. And in my submission, my learned friend really has no answer to that point, other than to point out it's a different clause in the same document. Now, my learned friend's dismissal of these other contextual indications in favour of the BBC's construction would, in my submission, be somewhat more powerful if you could point to a single use of the word interest in the entirety of this deed, which bore the meaning which he says it bears in the third proviso. So I've taken your lordship, your ladyship, to a number of examples where it bears the meaning that the BBC says he gives not. So the next question might arise in my mind is, well, would we get any assistance from the what's been called the B exception to the third proviso to the power of amendment? And that's the one where it's contemplated that if interests are affected, substantially equivalent benefits determined by the actuary can be provided instead. Now, in my submission...
So, Mr. Claimant, can I ask you a question? Because I'm a little confused here. On the one hand, you are pointing to rules in the scheme as it now stands, which were introduced in 2000 or possibly 2006, to support your interpretation of the word interest in 19.2. On the other hand, you say, well, it means what it always meant in 1949. So how do those two approaches mesh together?
Well,
I mean, if it means what it's always meant, then I don't see what help you get from looking at other provisions of the redrafted scheme. If, on the other hand, the other provisions of the redrafted scheme tell you what it means, what interest in 19.2 means, why do we go back to 1949?
Well, I'm going to do both to show you they both take you to the same place. The reason I am starting with the current deed is because that, I apprehend, is where your lordship was indicating that a current member would start when trying to find out the meaning of his or her benefits. And so I'm going through that deed and trying to explain why it is consistent with the meaning of interest for which I contend. I am not in any way shirking or attempting to avoid the fact that the provision was originally appearing in the 49 deed, and I will go on to address that in due course. But I didn't want anyone to think that I was ducking the meaning of this provision in the current deed. And the importance of it, as I understood my Lord Justice Lewison to be suggesting, is that if a member was starting to look for the interests, what interest means in the context of this deed, this is where he would start. In relation to the B exception, obviously, that's been the same throughout in any event, as indeed in substance as the whole of the power of amendment. And in my submission, what clearly appears from the B exception is that the draftsman is contemplating that interest and benefits will be actuarially interchangeable. And to that extent, I'm in agreement with Mr. Green. If interest has a wide meaning beyond benefits, it would be comparing apples with pears. So, at the very least, the B exception suggests that the very wide meaning suggested by the judge for interest is probably inapplicable, because such interest would not be actuarially interchangeable with benefits. If interest means past service rights, now just turning on whether it means past service rights or future service rights, exception B, again, is perfectly explicable. That what's being contemplated is you exchange past service benefits for actuarially equivalent past service benefits, DB to DC, and doing different DB benefits is also perfectly commonplace. Indeed, it's one of the specific exceptions permitted by Section 67 of the Pensions Act to modifications of past service benefits, is you can do it if you get actuarial equivalence. So it's doing something similar to Section 67, I would suggest, or it appears to be. But does the fact that interest can be exchanged for benefits suggest that interest can be swapped for the right to earn different future service benefits? Is benefits referring to future service benefits? I would say in relation to that, at best the position is neutral, but in my submission, the more natural meaning of the word benefits means a present benefit and not a right to continue in service and earn benefits in future. Now, the word benefits is used hundreds of times in this document. It refers to benefits in payment, it refers to benefits earned but which have not yet fallen into payment, contingent benefits, or prospective benefits as they're sometimes called, and it refers to discretionary benefits. But we've looked through and we do not think it refers in any other place to the ability or right to earn benefits through future service. If I give you a typical example of this use of benefits elsewhere in this scheme, if one goes to page 196, you'll see this is a provision for the transfer out of benefits, and obviously in that context under 12.2 sub-rule 1, in the middle of that paragraph it's talking about exchanging the benefits and paying a transfer value in place of the benefits, and clearly the benefits being transferred out are the past service benefits. And you can see similarly in the next provision, buyout, that relates to the members' past service benefits. That's page 197, sub-rule 1 of 12.3. And the closest we can find to the way benefits is used in exception B would be rule 9.6, which is at page 101, which refers to the payment.
Sorry, which rule?
This is rule 9.6 on page 181.
Thank you.
Which simply provides the trustees may, with the BBC's consent, award a different benefit equivalent to and in lieu of a benefit to which a person is entitled. And again, benefit in that's the only situation where we can find an example of an exchange of benefits similar to exception B, and the exchange of benefits is in relation to past service benefits. Now, I'm certainly not suggesting those examples are conclusive, but they are more consistent with the submission that the natural meaning of the reference to benefits in exception B is a reference to existing rights and not to the ability to continue in service to earn benefits in future. As for courage, in my submission, that doesn't assist the court at all in relation to this issue.
Mr. Tennant, I'm sorry to interrupt again, but the benefits referred to in exception B must mean benefits to be provided in the future, i.e. after the amendment, mustn't they?
They must, indeed. But if I could qualify that by saying they are provided in substitution for your existing benefits. So you don't earn those benefits. It's not talking about the ability to earn those benefits. It's saying, as under section 67, you have a set of past service benefits, and if you modify it, it's okay if they are exchanged for equivalent past service benefits. It doesn't connote any process of earning in my submission. Looking at courage, which is at Authorities Bundle 1, tab 2, page 49. Mr. Green drew the court's attention to this, in his submissions. The important point to note about this part of the judgment is that the issue that Mr. Justice Millett was dealing with here was simply whether past service rights included a future salary linkage. And it was in the context of an express definition that excluded future salary linkage from past service rights. The judge said what he said at the top of page 49. He says, between A to C, effectively, I see no reason in the absence of express definition to exclude any benefit to which a member's prospectively entitled if he continues in the same employment and which has been acquired by past contributions. So he's talking about prospective benefits arising out of past contributions. He's talking about then the salary link effectively having been acquired by past contributions. He was plainly not making a general observation that benefits meant future service benefits not yet earned there or indeed in any other situation. But if exception B does not rule out the possibility that the right to earn future service benefits are encompassed within the meaning of the word interests. And in my submission, the more natural meaning is that it suggests they're not. But are there any other indications that suggest that the draftsman of this deed, the parties, did not intend to protect the member's right to continued accrual? And so I look at the provisions of Rule 18, which is at page 214 of the bundle. Now, there's been much debate as to whether this is a power to stop contributions, a power to stop future accrual, or a power to put the scheme into winding up. In my submission, on its face, it plainly includes all three powers, so it's not perhaps helpful to label it one way or another. The rule, Rule 18.1, it's headed freezing and winding up, and Rule 18.1 is dealing with a power to freeze. The scheme will be frozen if the BBC gives a written notice to the trustees terminating its liability to contribute to the scheme. That's terminating its liability under the scheme, not necessarily under contract, as my learned friend Mr. Green said. Now, unless contract simply adopts the provisions of the scheme, which may be what's in it. And then 18.2 goes on to explain what the effects of freezing are, what the effect of serving that notice is. Following the scheme becoming frozen, and this is B, unless the trustees decide otherwise, either in individual cases or generally, any active member will be treated as leaving service at the freezing event, and no service after will be that pensionable service. And that, in my opinion, is spelling out the consequences of the scheme having been frozen, unless the trustees decide to the contrary. Now, in my submission, I hear Mr. Green's submission that this is just a blanket power to wind up the scheme, and I'm entitled to address that submission in my submission by looking at what it actually says. What it appears to say is that this is not a power to completely freeze or terminate pensionable service for all members. The trustee clearly has a discretion to do that in individual cases or generally. So it's not necessarily implying the whole scheme will be terminated in terms of pensionable service in relation to the whole scheme will be terminated. Nor, in my submission, does freezing the scheme to accrual for some or all members under Rule 18 necessitate a winding up. Inevitably, if you freeze a scheme to future accrual so that nothing emerges as a benefit under the scheme, eventually, of course, it will lead to winding up because there is no long-term future for the scheme. It's not continuing to refresh and renew itself. So obviously the ultimate impact will be winding up.
Sorry, just all that's happened at this stage, let's say the trustees do decide otherwise, is the BBC has stopped contributing. Then it says, unless the trustees decide otherwise, the active members are treated as leaving service. If the trustee does decide otherwise, they stay in service. It's just the fact that the BBC isn't contributing.
Yeah, that would...
and if the scheme's in surplus, perhaps that doesn't matter.
Yes, but the point on which it's obviously not
I'm just trying to understand. You're effectively saying it will end up having to wind up. Well,
no, it's certainly not my case that it will inevitably end up being wound up in the sense of at any time in the immediate future. My case is that the trustee might decide to, even if they exercise a power to terminate pensionable service for certain members, it would not inevitably involve a wind up. That I would accept that. The only point I'm trying to make here is that together the trustees and the employer have powers to terminate completely pensionable service for certain employees or all employees. And that I say is the effect of 18.1 and 18.1.
And pausing there, if to the extent that happens, they effectively are in the position of deferred members, aren't
Yes.
they?
Yes.
That's all that's happened.
But yes, I mean, and the trustee does then have a discretion as to whether to wind up the scheme under 18.3. So that it says at any time the trustees may resolve to wind up the scheme. So what, just looking at these provisions, I get, and I mean also bear in mind that even if the trustee decides to wind up the scheme, that will still result in a total termination of pensionable service. Yeah. So I ask myself, if the draftsman is conferring powers to bring pensionable service to an end for some members, or indeed all members, completely, and conferring those powers on the employer and the trustee, is there any reason why the amendment power would seek to protect the right to continue in pensionable service from amendment? And my answer to that question is clearly no. On the contrary, I say that would be a very odd conclusion to reach. And quite apart from anything else, it's a very odd conclusion to reach for this reason. It would arise as a result of the way a fetter on an amendment power operated. Now, fetters on amendment powers are, in my submission, self-evidently there to protect rights. They are not there to create rights. They prevent rights being overridden. They don't themselves generally create them. If you want to, as a draftsman or parties to a deed, to create a right to something, you confer it under the benefit structure, and the fetter will then protect that right. So for that reason, in my submission, it would be even odder to create a right to future accrual, in my submission, by the back door, by construing a proviso to a fetter as if it was there to protect the ability to accrue, which was not otherwise part of the scheme. Because
but Mr. Tennant, the right to accrual is there under the general terms of the scheme.
But that is
subject only to continuing employment, but it's also subject to all sorts of other contingencies.
Yes, but under the scheme itself, as we have just seen, there is a power to terminate the right to pensionable service. And all I'm asking at this, all I'm saying at this stage is, in my submission, if you have conferred a right to terminate pensionable service between the employer and the trustee under Section 18, why would you be protecting the same ability under Rule 18? And as to that, in my submission, that doesn't look a natural thing to do. My learned friend Mr. Spink's response to that was the power of amendment was concerned with modifications, and Rule 18 concerned with termination. But of course, the first point to make about that is that the power to modify future accrual under Rule 18 also extends to a power to terminate future accrual. And further, to the extent that modification is less draconian than completely freezing or terminating future accrual under Rule 18, why would you wish to prevent the less drastic step but permit the more drastic one? And so I say that too doesn't stand on its own, but that too supports the view that interest has the meaning for which the BBC contend. Now, the contextual matters on which my learned friend relies positively to support interest being given a wider meaning are threefold. He points to differences between the third and fourth provisos, he points to the fifth proviso, and he points to the absence of a temporal limitation. And I'll just take his submissions on each of those in turn. In looking at the differences between the third and fourth provisos to the power of amendment, I bear in mind my learned friend's point that as a result of the introduction of a right to a deferred pension in 1955, the existing wording of Proviso 4, which protects the interests of pensioners, now protects not only pensions in payment, but deferred pensioners. So there's no doubt that 1955 clearly changed the scope of what fell within the existing wording of the fourth proviso to the power of amendment. What it did not do in my submission was to change the scope of what was protected by the fourth proviso or the third proviso, the wording of neither of which was changed in any way. Now, my learned friend suggested in his submissions that deferred members may have been deliberately allocated to the fourth proviso with different protections because their past service rights were being protected, whereas active members were in the third proviso because their past service rights included the right to future accrual, which were different in nature. And so I asked myself, did the draftsman decide to leave in the fourth proviso deferred members because he thought they had different interests to actives, or are there other explanations of that evident on the face of this document? And the first explanation I gave in relation to pensioners in our skeleton was that elderly and infirm pensioners got more stringent protection in a whole host of pensions situations, and that wasn't necessarily a reason for concluding that there was any difference in benefit. Pensioners' past service benefits are routinely protected more highly than active members' past service benefits because that reflects policy decisions of people involved in pensions. So my learned friend then pointed out, well, that doesn't apply to deferreds because they may be very young. But there were in fact two reasons we gave in our skeleton at 43.3, which is at Core Bundle 2, page 37, in relation to the disparity of active members and pensioners, whether current or deferred. And the second reason was that it would not be appropriate to allow the pension rights of active of current or deferred pensioners to be varied by majority vote in a meeting of those deferred pensioners or pensioners. There were two problems with it. First, and perhaps most obviously, because deferred pensioners, like other pensioners, have by definition left employment at the BBC and may be working for competitors, it's going to be much more difficult to convene a meeting if people are not already working together in similar places. But second, and just as importantly, like other pensioners, deferreds have completely different interests from an active member in respect of their past service benefits. So if the BBC is right that the past service rights of active members are protected by the third proviso, one of the obvious instances in which those active members might be persuaded to vote in a meeting to give up those past service rights would be in the event that their future employment was threatened by the employer being unable to afford the pension scheme. Actives will always have an interest in saving the employer, which will not be true of deferreds or pensioners. It's unreal in my submission to expect a deferred pensioner who's now working for ITV to vote through a change which damages their past service interests simply to benefit the BBC. So if we're asking ourselves why in the current deed deferreds might be found in the fourth proviso and active in thirds, even if they all have to cover the same rights, there are two very good answers to that. Firstly, the fourth proviso naturally already covered the interests of deferred, so they just fell within it. And secondly, leaving deferreds in the fourth proviso and not the third made perfect sense because it simply wasn't realistic to expect them to vote away their rights in a meeting in the same way as active members. So, in my submission, the difference between the third and fourth proviso are completely neutral as to the question of whether future service rights are protected. In relation to the fifth proviso, I've already given my explanation of that in my opening. The judge did not put great weight on it, nor in my submission did my learned friend. Again, there are obvious reasons why the draftsman might have added a reference to section 67 simply as a backstop, or because the protections of the third proviso were different to the protections offered by section 67. In other words, the leeways out of the third proviso were different from the leeways out of section 67 in the event that you infringe past service rights. So, in my submission, it can't plausibly be suggested either that the addition of the fifth proviso suggests that the third proviso and section 67 covered substantially different ground. And I would just note here, it's equally true that section 67 and the fourth proviso cover the same benefits, yet no one would suggest that adding the reference to section 67 means that the fourth proviso covered different ground. Obviously, one difference between the effect of section 67 and the fourth proviso is the fact that the exceptions for proviso 4 are different from the exceptions to section 67. But I've just pointed out that is exactly true of the third proviso as well. So again, this point in my submission is no more than neutral. And the only other point which was made was in relation to the temporal limitation. Well, in my submission, which I've already made, there was simply no requirement for a temporal limitation on the BBC's construction, because if interests meant past service rights, they necessarily did not extend to rights which had yet to be earned in the future. That is an explanation of why there would not be a temporal limitation. So, whatever assistance my learned friend gets from those points has to be set against what I would suggest are the many other and clearer contextual indications in the BBC's favour, not least 10.6 and the power to terminate accrual and the other the uses in the second and fourth provisos. Now, the other contextual indication which was relied on was what I might describe as the far horizon argument. But no one is suggesting that runs or would occur to someone looking at the current deed. It arose in relation to the 1949 deed, and so I would like to explain why that argument does not run even in relation to the 1949 deed. So if we could now turn to tab 2 of this bundle and look at the 1949 deed. Exactly the same type of benefits, not exactly the same number of benefits, but the same type of benefits are being offered under the 1949 deed as the current deed. In my submission, I'll make that good. The real difference between these deeds, and the only really difference, is that the current deed just offers more generous benefits than the 1949 deed in certain circumstances. There is nothing in the benefit structure of the 1949 deed which justifies the suggestion that on the BBC's construction the power amendment would have nothing to bite on, or justifies the inference that the party to that deed would have needed to protect the ability to accrue future benefits, to protect the existing rights of members under that deed. I want to take this by looking at the main benefits under the 1949 deed in turn. And not all the benefits, but similar points could be made. The first is a right to a pension on retirement at 65. That's the right under Rule 6. The value of that pension is built up by each year of service. It builds up in blocks of n/60ths times the member's salary, where n is the number of years in service. And I'll explain how that works in practice in a moment. There's then a right to a deferred pension. Sorry, if I said a right to a pension at 65, I'm misspeaking. The actual retirement is a right to a pension at NRA under the scheme, normal retirement age, which was 60. So insofar as I have referred to 65, I should have referred to 60. But it obviously makes no difference to the point being made. There's secondly a right to a deferred pension or an annuity, which is a deferred annuity, at age 60 on the contingency of winding up under Rule 22. Again, that would be based on n/60th times a member's salary, and the actuary would purchase an annuity which was actuarially equivalent to that. Then there is a right to lump sum benefits contingently on leaving service under, I think, Rule 8, and that is also built up. If the member is contributing 6% of salary each year, it builds up at the rate of 6% of salary each year plus interest on that salary. And the same with the right to a lump sum payment on death. Now, even though, and this is a very important point in relation to this deed, even though none of these benefits are immediately payable, the value to the member of the contingent right to each benefit increases as the member builds them up through contributions and service and approaches, if the contingency gets closer, approaches that contingency occurring. So at any time, one can test whether the value of the NRA pension is increasing by hypothesising what would be paid to the member for his right to a retirement pension at 60. So let's take the example of after 10 years service when the member is 49 and after 20 years service when he is 59. Now after 10 years his pension is worth 10/60th or 1/60th of salary payable in 11 years' time. After 20 years it's worth 20/60th or 1/3 of salary payable in 1 year's time. So you can clearly see it is increasing in value over time. And although he can't sell them, the member asks himself, what has the value of my rights to me increased? It has clearly increased. Similarly, the value of the lump sum benefits, although less valuable, do increase and build up over time. So after 10 years service, the member, having paid 6% of salary, will have a right to a lump sum benefit of 60% of his average salary over the period, plus interest. After 20 years, he will have a right to a lump sum of 120% of his average salary over the period, plus interest. Now, the power of amendment protects each of those individual rights from amendment as they build up. Thus, in relation to the NRA pension, no amendment to that retirement pension can have the effect of reducing the value of the pension on retirement to below what has already been built up by the member in respect of that benefit, because that is his interest in the scheme. So if you assume an amendment to reduce the NRA pension in respect of past accrual to 1/70th times actual service, it can't be done. So when a member is 59, he's reached 59, and he's done his 20-year service, his right to a pension of 1/3 of his salary is his at that time. It's fixed and cannot be reduced by the power of amendment. It is irrelevant that he may never make it that final year. He has a right, which if he does make it, is going to be quite a valuable one, and it can't be taken away from him by amendment, self-evidently. And that would be an obvious and useful function of the power of amendment. Similarly, an attempt to change the existing value based on past service of the pension which would be payable in the event of a winding up would also be invalid. You can't exercise the power of amendment to reduce the entitlement on a winding up because that right has been earned by past service. And just because the winding up has not occurred and may never occur does not alter the fact that it has already been built up and earned and will be protected. Exactly the same analysis applies in relation to the lump sum benefits. So in my submission, my learned friend is simply incorrect to suggest in his skeleton, paragraph 54, which I may have got the reference, it's at core, maybe at core page 54, I'll just get that reference, that because benefits payable on different the benefits are all payable on different contingencies, which individually may not happen, those rights formed one individual package such that an entitlement to a pension only arose, other than on winding up, if the member actually retired from service at NRA. It is not correct to say that an entitlement to a pension, NRA pension, only arose if a member retired from service at NRA. My friend, with respect, my learned friend, is confusing the question of whether a contingent entitlement has fallen into payment with the question of whether a contingent entitlement exists. Those are not the same things. Now, I hope it's also apparent from this analysis that you can see that whether you get a deferred pension on leaving service or you get a lump sum benefit makes no difference to the nature of the remaining benefits or what is protected by the power of amendment in respect of those benefits under the 49 deed. The nature of all the other benefits remains exactly the same, and the protection afforded to them by the power of amendment remains exactly the same. All it means is that now that the member has also a leaving service pension rather than a lump sum pension, the fifth proviso also protects his interest in that separate contingent right to a deferred pension at 60 built up by service prior to the amendment, and so it too cannot be amended. In my submission, therefore, there is no reason to conclude that because of the absence of a leaving service pension, it necessitated or justified additional protections being given to the right to earn future service benefits in the third proviso to the power of amendment. Now, at various points in his submissions yesterday, my learned friend Mr. Spink talked in terms of that right to future accrual being necessary to avoid the level of a member's right to a pension being watered down or whittled away. So to give you a reference, day 2, page 228, line 25, members were being encouraged to commit themselves to the BBC service in the long term for the reward of a pension and were being provided with some protection, some, by which I apprehend he's talking about future salary linkage, future service accrual, because of the exceptions to the proviso against making that commitment only for the level of that potential reward to be watered down. So what he's saying, these were protections against the possibility of that potential reward being watered down. And I think on other occasions, he may have used the word whittled away. That is simply not correct. It's important to be absolutely clear that if a member has a right to a pension on retirement from service at 60, based on 20 years service, and has, say, 10 years to go before it falls into payment, an amendment which terminated or reduced the value of future pensionable service at that point would not have any effect on the member's right to receive a pension at NRA based on 20 years service. So I can make that good by just looking at Rule 6, which is at page 22. The requirement for that pension to be paid is that a member retires from service. It does not say, sorry, my lady, did you?
Yeah.
The requirement in Rule 6 for that pension to be paid is that the member retires from service. It does not say that the member has to retire from contributory service or pensionable service. Whether or not he's in contributory service does not affect the member's entitlement to a pension based on past contributory service falling into payment if he retires, when he retires from service at age 60. So not guaranteeing the member's ability to add to the pension, yet further years of accrual, not giving him the opportunity, guaranteeing to him the ability to build up further blocks, does not mean the value of the existing pension is being whittled away. It remains the same at all times and is protected by the power of amendment from being whittled away. Stays exactly the same and is protected from being whittled away. Now, as a wider point, while we would not disagree with the proposition put forward by my learned friend Mr. Spink that this was a long service scheme in the sense that it gave better benefits to those who remained in employment for longer, it incentivised the remaining in employment. In a sense, that makes it even less important that the scheme would need to guarantee that service would also continue to accrue further benefits. Just economically, an employee at 55 with a pension due at 60 already has an incentive to stay in service until 60 to get that pension. You don't have to promise to keep the scheme open to accrual so that the value of that pension will be added to as well. Pension schemes generally do not do this. Pensions are a reward for service completed and contributions paid. They're not rewards for service yet to be completed and contributions not yet paid. And I think some of the points I've made, hopefully, are relevant to the question posed by my Lady Justice Falk on Tuesday to me, which is at day 1, page 119, line 19 onwards, where Lady Justice Falk said, I think maybe the key distinction you're drawing is between what you've just described as earned rights, so many 60ths, by reference to years of service already undertaken, and future service. What I'm struggling with is in 1949, where there was not a leaving service pension, your so-called earned pension is entirely dependent on you remaining in this employment or in employment with the BBC until you're age 60. And I'm trying to understand the difference between that and a future pension, the future years which you say are not covered, which are similarly dependent on you staying in employment with the BBC. Now, if we were talking about, it's important to distinguish here between contributory service and service here, and I'm not sure what your ladyship had in mind. If the question is directed at just service, there is no difference between the right to the pension at NRA that has already been earned and the pension that the member will get if he simply remains in service, with contributory service having ceased. He will still get the pension he has already built up prior to the amendment at NRA. Rights to earned pensions are clearly, everyone accepts, protected by the word interest. And if the member had a right to such a pension based on past service before the amendment, then if he fulfills the conditions for the payment of that right, for it falling into payment, i.e. retiring at 60, he will get the right paid on the basis of his past service, whether or not he has a right to, at that point, continue accrual through future contributory service or pensionable service under the scheme. The payment does not depend on him being in contributory service under the scheme. It depends on him being in service. If the question is directed instead at contributory service, then that, in my submission, is a very different matter. In my submission, there is a great difference from the point of view of the member who is considering what his interest might be between the two matters contrasted in my ladyship's question. The first is a pension that has already been earned by past service and paid for by the member's contributions, which he will get on retirement from service at NRA. It's been built up in building blocks for past service. The second is, in effect, an additional further block of pension on top of his first pension, which the member has not yet earned by service, for which he has not yet paid contributions, and which he will only earn if he remains in contributory service to NRA, not service. And if nothing happens to pensionable service being frozen in the meantime. And in my submission, a member would clearly understand that the pension based on past service and already paid for by his past contributions is part of his interests under the scheme and could not be taken away. But a member of this or any other scheme would not regard as part of his interests protected from amendment an additional pension on top of the one he's actually earned, simply because that further additional pension will, if it is earned, be payable on the same contingency as the pension which he's actually earned. It's a thing of a completely different nature in my submission. And again, you will note that the existence or absence of a leaving service pension in this scenario does not affect the nature of either of those benefits. They are exactly the same whether or not the scheme provides a deferred pension in the event of a different contingency, which is the member leaving service. And obviously, when the member looks at the word interest, he's not simply just looking at the interest in isolation, he is taking account of all the contextual indications in the deed which is before him, whether that be the current deed or whether he gets access to the 1949 deed. And obviously, in relation to that, I'm not going to repeat my submissions. You have my submissions in relation to the 1949 deed context. They are exactly to similar effect to the ones I've made. I rely on the second and fourth provisos and the termination power. The only difference is that I do not have the contextual assistance of Rule 10.6 and 10.7, but I do have the provisions, the winding up provisions in Rule 22, which also refer to interests of members in the sense of rights to past service benefits. Okay. So that's all I propose to say in relation to future salary linkage. I'm going to be in relation to future benefit accrual. I'm going to be very short on the subject of salary linkage.
Thank you. Yes.
The first point I wish to make is that the answer to salary linkage does not affect the analysis in relation to future service benefits. I accept you can justify salary linkage on the basis that it's attributable to past service. There is no such argument in relation to future service benefits. The court already has my argument as a matter of principle why salary linkage, even if it is referred to in other contexts as part of a member's past service rights, has a different nature to other past service rights, other contingent rights to benefits. It's not a contingent right to benefits, it's akin to a discretionary right to be considered for a benefit every time there's a contractual variation of the, when and if there's a contractual variation of the employment contract. And that's all I propose to say about that. I'm going to, in relation to Bradbury, just confine myself very briefly to two observations. I do accept the Court of Appeal did not directly address the question of the scope of the power of amendment in the sense of judging the validity of the amendment. In my respectful submission, my learned friend Mr. Green goes too far when he says there was no suggestion that the amendment had been invalidly introduced. In my submission, there was clearly a suggestion that the amendment had been invalidly introduced, or would have been invalidly introduced had it borne the construction which the Court of Appeal found it did bear. And that is Mr. Stafford's submission at 39 and 40. And in my submission, the reasoning in relation to the construction point is not simply confined to that at 34 to 38. The construction point was also being addressed, and specifically Mr. Stafford's use on behalf of Mr. Bradbury of the potential invalidity point as an aid to construction of the relevant power. That was also being addressed so as part of the construction question at 39 to 42, and I don't accept my learned friend's Mr. Green's submission that the court was there simply repeating what it had already said at 34 to 38. It was addressing that specific argument by reference to the points it had already made, but it was addressing the question of whether the actuary could have concluded that a certificate for the amendment could have been given. Whether my learned friend is right that it was about contractual rights to rate the final salary link or a right to do so under the scheme, I confine myself only to this observation. On either basis, the BBC would have either a contractual right to grade the future salary link or a right to do so under the scheme. And it doesn't matter which if the BBC has that power to declare salary increases non-pensionable. And that's obviously an important point to be clear about from the BBC's perspective. That's all I propose to say on that.
Lady, I'm sorry to rise to my feet, but I won't detain you or the rest of the court for more than just a moment. I simply would like to observe that learned friend has taken the linguistic odyssey further into consideration of the meaning of the word benefits in certain provisions in the current deed, which I've not addressed in my submissions because they've never been raised before. He's done so, I accept, in response to the discussions that have developed about the meaning or the equivalence of interests and benefits. I'm not going to ask you for permission to make detailed submissions on what he said about the meaning of the word benefits in those provisions. For this simple reason, I was quite careful in my submissions not to say too much about benefits and the meaning of the word benefits in isolation, and in particular whether or not it's capable of being read without a temporal limitation, which was the point that my learned friend Mr. Green was making on the basis of courage. For the avoidance of doubt, benefits clearly is in our submission capable of being read as having no temporal limitation and applying to future service benefits as well as past service benefits. In the same way as interests is capable of doing both, and it all depends on the context. In certain contexts, the content of the word benefits may be a reference to future service benefits or only past service benefits, in the same way as that can apply to interests. And the exercise that my learned friend indulged in at the beginning of his submissions by taking you to new provisions that we haven't considered in the current deed where the word benefit appears was an attempt to suggest that in those particular contexts it only is referring to past service benefits. I'm not going to engage with that. I'm not going to say whether I agree or disagree, because that requires a careful analysis of the context of a different provision from the provision that we are concerned with, and in this case, with a different word from the word that we are concerned with. And I'm going to leave it there, if I may. And that A, saves time, and B, repeats my point, which my learned friend's got, and which he said everything he can possibly say about, the contextual sides of our arguments on interest. But with respect, do take care
I think we
with those submissions that he made about the meaning of the word benefits in those particular provisions. We could have had a significant debate about how benefits is used in the current deed. I've avoided doing that, and I respectfully suggest that this court takes some care in doing so itself. For precisely the same reason that we need to be careful about other uses of interest in other provisions than in the third proviso.
Thank you, Mrs.
The only observation I want to make is my understanding was my learned friend did adopt and endorse my learned friend Mr. Green's submissions in relation to that provision.
We understand.
Well,
Right,
up to
I
a
think
point.
I think we should leave it there. Thank you to council for your submissions. Thank you to those behind them. We know the amount of work that can go into an appeal like this. You won't be surprised to hear that we'll be reserving our judgments. Drafts will be circulated in due course in the normal way to those on the list that should already have been provided. We'd ask for corrections, typographical and that sort, no attempt to re-argue, please. We also will ask that you attempt to agree a draft order, and to the extent that you cannot, file short written submissions so that an order can be finalised in time for hand down with no further hearing. You'll all be well aware of the importance of the embargo emphasised in the Counsel General for Wales case and the significance or the importance of not breaching that embargo. Thank you again for your submissions.
Court is able.